Hello, good morning. Welcome to The Big Issue. The Big Issue is live on 97.3 Citi FM. It's your platform for incisive analysis and riveting conversation. My name is Selom Adonu. As always, the show is live and interactive. This morning, there are a number of issues that we hope to bring to your attention. The first one having to do with the recall of Parliament. Parliament reconvened yesterday for some business, key amongst them being the approval of President's ministerial and deputy ministerial nominees. That was done. The minority walked out. They said they don't want to be a part of that. They want the presidency or the government to signal the fact that they feel the times and that their government or its government will not be bloated, something that will affect, which will become a burden, as it were, on the taxpayer. So on that position of principle, they said they were unable to partake in that process. So that was it, and a few other things, the Garrick loan and a few other things were passed. The minority has signaled that they will petition the World Bank on some issues related to that particular loan agreement. Main on the list has to do with the special prosecutor, former special prosecutor on the heels of the current special prosecutor. Martin Amidu has petitioned the president for the removal of current special prosecutor, Kisi Ejabin. He mentions a number of issues, including the fact that Kisi Ejabin allegedly is usurping the powers of the president and a few other things. Indeed, that matter has been forwarded to the CJ. He calls it accroachment of authority, inducement of staff from sister law enforcement agencies, abuse of citizens' rights through arrest and detention, abuse of the judiciary, procurement breaches, refusal to comply with RTI request. These are the basis for which Martin Amidu is asking the president to initiate the process to remove Kisi Ejabin from office as special prosecutor. We will have time this morning to delve into each of these grounds and see if indeed these are grounds solid enough to occasion the removal of Kisi Ejabin from office. Indeed, by law, the president, upon receipt of the petition, must forward it to the Chief Justice. The president has done so. Now the Chief Justice is written to Kisi Ejabin for a comment on the allegations, after which the Chief Justice by law will determine whether a prima facie case has been made against Kisi Ejabin. After that, a committee, if indeed a prima facie case has been made against him, as will be determined by the Chief Justice, a committee will be set up by the Chief Justice to now look into the specific details of the allegations. After that, the committee's report will be sent to the CJ, and the CJ will forward it to the president. The president will have to deal with the recommendations of that particular committee. So we are at the second stage of it. Petition has been sent to the president. The president has now forwarded it to CJ, and CJ has transmitted same to Kisi Ejabin. In fact, the third stage of that process. So that's where we are. We'll delve into that and see what may come out of it. This is not the first time a thing like that has happened. You remember Charlotte said she was removed from office using a similar process. Indeed, that is a constitutional process for removing superior court judges from office. Indeed, the office of the special prosecutor is being placed in that category. Now, the Citi has not been doing well lately. In fact, it's not been doing well for a while, but lately it's been under heavy pressure from the dollar. Businesses, industries, etc. are really under the pressure, which in turn will affect you and I, the consumer, because the businessman or the manufacturer will not swallow the cost. The cost will be passed on to the consumer. Tell us your experience about the Citi dollar rate, how it is affecting you, and what you think government could do to help the situation. We talk about the fact that the structure of our economy has not been good or is the problem. But we've known this for the past 20 years. What have we been doing about this? Baumia said that he was going to arrest the Citi or the dollar. What has happened to that promise? The good for oil policy or program was to help reduce the rate of depreciation. What has happened to that as well? What new propositions or proposals are on the table? We will delve into that later on in the show as well. I'll take a short break. When I return, I will introduce my guests, provide some updates, and then we'll delve into the discussions proper. My name is Selam Adonu. This is The Big Issue. You are welcome. Welcome back. This is The Big Issue. 3 key issues on the plate. Parliament reconvenes. Parliament passed the president's list of nominees. The minority staged a walkout. They said they don't want to be part of that because they feel the citizens are being burdened with the cost of running government. Garrett loan has been approved. Minority signals that they will petition the World Bank over some issues. Number 2, former special prosecutor wants current special prosecutor removed from office. Are you surprised that it is Martin Amidu of all people involved in this, or you think it's a position of principle? What has Citi done? Martin Amidu lists a number of issues upon which he hopes to ground, or he grounds his petition. The petition has been submitted to the president. The president by law has transmitted same to the CJ. The CJ, based on the petition, is written to Citi, the man in the center of it all, for a response. Based on that response, the Chief Justice by law would determine whether a prima facie case has been made against the special prosecutor. If so, a committee will be set up to investigate the specific allegations. The details of that, or the result of that, in terms of recommendations, will be sent back to the CJ for onward delivery to the president. The president will only follow the recommendations as the committee has determined. Also, we will look at the matter of the cedi and the dollar. The cedi hasn't been doing well for a while, but in the last week or so, or in the last month, it's been terrible. The dollar to the cedi is around $1 to 15 cedis. That is quite huge. If you are changing dollars to cedis, you will be a happy person. But if you're changing cedis to dollars, you will see how difficult it is. Also, that has implication on doing business, etc., cost of living, amongst other things. Tell us your experience. We'll delve into the details. What can we do? We've proffered many solutions in the past, key amongst them being changing the structure of the economy. What else can we do? Because it does appear that that structure is not changing anytime soon. Remember the talk about the Gettysburg economy? What has happened to that? We'll delve into all of that this morning. Now, the minority in Parliament has disclosed that it will petition the World Bank over the alleged mismanagement of the $200 million loan facility approved by the House for the Greater Accra Resilient and Integrated Development (GARID) project. This follows the approval of another $150 million facility for the ongoing GARID project by Parliament, with the aim of mitigating the impact of flooding in Accra. Here are excerpts from the parliamentary proceedings.
$50 million again for a project that you've already gotten $200 million for. $200 million for. Now, Speaker, for us on this side, we want to plead with you to call on World Bank or your office to institute a forensic audit on this project. We are saying this because we've noticed that payments were made, but there's nothing to show for this project. And so why should we continue paying money or borrowing more money, whilst we know in the recent past, a $200 million was also taken, and some of our colleagues are in court. That $200 million for Sakime project, you can see physical works that have been done in Sakime. But with this, you cannot see anything tangible that merits $200 million. So, Speaker, in this occasion, this particular IBA loan from the World Bank, all of us, the Speaker, has rejected this loan. Because the Speaker clearly, Ghana does not need to approve this loan. The Speaker, the $200 million that we approved earlier has been misappropriated. Clearly, Mr. Speaker, it has been misappropriated. Mr. Speaker, at best, it has been misapplied. Mr. Speaker, the evidence is there for all of us. But I only want to plead with this House, Mr. Speaker, please commit part of Parliament's budget to commission a forensic audit on this matter. In recent past, this House has questioned some disbursement made by the World Bank Country Office. Mr. Speaker, I want to serve a notice that immediately after this, I'm going to petition the World Bank Country Office and World Bank HQ in Washington, because this is not the way to spend taxpayers' money. First is a claim that the amounts for the original project have not been accounted for. Mr. Speaker, that is not correct. At the committee meeting, questions were raised and a full accounting was done for the monies that were made available. And this report, your committee's report, includes that full detail, which I'll go into here. If there are members who are of the view that they are not necessarily satisfied with the utilization of funds, that was why an offer was made to go to the site, to go and inspect, so that those who still had outstanding difficulties with the utilization could have their outstanding difficulties satisfied.
The new ministers and deputy ministers of state designated by President Akufo-Addo were also approved by the House following the adoption of the 35th report of the Appointments Committee.
We cannot, Mr. Speaker, in good conscience, support the approval of these nominees, especially when this government has been reckless, wasteful, Mr. Speaker, and most importantly, very insensitive to the plight of the people of Ghana. Right, Honorable Speaker, the NDC Minority Caucus will not and cannot take part in this decision to further increase the size of this administration. Mr. Speaker, we cannot be part of this. Finally, Mr. Speaker, let the record reflect that the NDC Minority Caucus cannot be part of this approval process. To further increase the size of this government, Mr. Speaker, let the record reflect. With these few words, Mr. Speaker, I want to signal that we are working out, and let it be recorded that they took these decisions themselves. We are not part of it. Mr. Speaker, we have counted their numbers already, and we know their numbers. Let the record reflect that the NDC is not part of this approval process. If you don't care, we care. If you don't care, we care, and we will be part of this. Stay and approve it, and in the end, take responsibility for what you are doing to the people of Ghana. Thank you, Mr. Speaker.
Responsibility, work out, go. Bye-bye, bye-bye, bye-bye. To conclude, that because it is an election year, they want to do this for the optics, for the politics of it.
All right, so that was those were some images and sounds from Parliament yesterday following their recall. To help us do the discussion this morning, Kofi Adams, Member of Parliament for Boeing constituency, the Honorable Samuel Ayepe, former Member of Parliament for Ayen-Suano in the Eastern region. We'll also be joined by Franklin Kujo, who is President of Imani Africa. Gentlemen, welcome to the program.
Thank you, my brother. How are you?
Very good. Kofi, let me start off with you. You were in Parliament yesterday. Parliament was recalled. Parliament should reconvene normally at the end of the month. Is that correct? Parliament normally should reconvene towards the end of the month, thereabout.
There's no normal time for Parliament to reconvene.
No, what was your scheduled date of reconvening?
Well, when we adjourn, such as we do, we will adjourn Senate, and it's up to the Speaker to determine when we have to come. But except that, in this case, it was as a result of a petition from the majority side, and the Constitution makes provision for that, that a minimum of 15% of the total membership of Parliament could request the Speaker to summon Parliament. And once they meet that threshold and they submit a petition, a memorandum, as a petition to the Speaker has within 7 days to give indication as to when Parliament must sit. And it should not take more than another 7 days after the 7-day count when he's supposed to make that decision. Weekends are added. And so based on that, the petition from the majority side presented to Mr. Speaker resulted in us being recalled to meet yesterday to consider some business they consider as agent, and which we thought was not agent, because these were businesses that have been before the House, and we did not handle them and went on recess. So we didn't see the agency of it. But it is within the law that once 15% of members of Parliament petition Mr. Speaker through a memo, he's supposed to go through the processes and summon Parliament to consider whatever business it was. So we did that yesterday.
So the key amongst the businesses were the issue of the ministerial nominees, the Garrett funding, etc. Talk to me about the ministerial nominees. I mean, some ministers have been reshuffled out and others brought in. Was it a view of the minority that the persons who were taken out of government should not be replaced?
Why should they not be replaced? But what we said was that there's an opportunity for the president to, in a way, restructure his government as is being done around the world. They are good at quoting problems that confront the world, but they are not good at quoting best practices that is happening around. Just neighboring Cote d'Ivoire, when they were confronted with all the challenges, what did they do? The president there saw it necessary to reduce size of government. But in our case, the president is rather enlarging the government. He's creating many more portfolios. So if you have an executive that wants to complain, raise every international issue as if it's happening right here, but they don't want to copy the best practices that is happening around the world, then we as a responsible opposition, a responsible government in waiting, will not just sit idle by and allow that to go on. We have to raise such issues and point to him that your colleague, age mate, Alassane Ouattara, is doing something better. Why can't you learn from him in terms of realigning government, reducing size of government? So we thought he would take advantage of this long period to redo something, but no. What we are experiencing is even more additions. He has even appointed more persons, and yesterday that appointment was read to, or nomination was read to the House and referred to the Appointments Committee for its consideration, and a report will be submitted later. So we are not saying that we shouldn't have ministers at all, no, but we are saying take advantage and realign government, put some ministries together, reduce number of deputies in some areas, and it will go a long way to indicate your preparedness to also tighten your belt. But loosening your belt when you are telling the citizenry to tighten their belt and suffer the more, we don't go for that. But you see, the worrying situation is for me not even the nominees, but like you said, the Garrett facility was also another one that we thought, you've taken $200 million. Nothing has come out of it. You took a portion of it claiming that per the arrangement that you had with World Bank, you could use some part of that facility to support COVID. COVID funds you haven't accounted for. The Auditor General, of course, have done some auditing, and even that was further questioned because the Auditor General didn't speak to some sources of funds that even the Ministry of Finance itself had given indication and Parliament knew of. That was where many of us raised concerns that we wanted Parliament to properly establish a committee to go into the COVID-19 expenditure. The majority side opposed it. But finally, when the Auditor General's report on COVID came out, and we found that some huge funding which came to us was not captured in the Auditor General's report, then people began to observe the sense in the minority side, the NDC side, call for a parliamentary probe into the COVID-19 expenditure, because at least in Parliament everything passes there. So we have the data, we'll be able to question and get virtually every other information. But just to say that the COVID-19 expenditures have not been properly accounted for. The Auditor General's report, the special audit on COVID, which he has submitted to Parliament, we are yet to even go into it as a Public Accounts Committee, which I'm a member of. We are yet to even do that. The Parliamentary Committee that has been established, the Joint Committee of Health and Finance to look into the COVID-19 expenditure have not concluded their work. They haven't gone far at all with their work. So we don't even know how the $65 million of the original Gary funding of $200 million was spent, whether it was spent properly or not, that aside. Then the remaining $135 million, they could only account for about $42 million. So the rest of the money, you can't account for it. Contractors who have been given mobilization, some $2 million, they call them, he say he doesn't even know the site.
But he took the money.
He took the money. The government gave him the money. He didn't just take the money, they gave him the money. But he doesn't even know the site. Others who have also taken, some have done only 20% of the work, 18% of the work. 3 contractors who were on site out of the 9 or so lots, 3 of them who were working, 20%, 18%, and another lower percentage. Meaning that no proper work has been done as far as the $200 million is concerned. Then you are asking for more. And yesterday, when you listen to some of them speak to defend that position, say, oh, compensation have not been paid, and that's the difficulty for some of them. That is why they have not been able to return to site. We are talking about contractors who say they don't even know their site. They don't even know the site for which reason they've been awarded contract and given $2 million as mobilization. And we want to approve more. But you see, for that one, yesterday we did our best. We had the numbers that we had, and if you read constitutional provision, you are a lawyer. If you read Article 181, clause 1, it's very clear on what should have happened. And I don't know if you can help me, since I've seen that you are flipping through your constitution to be able to read it. It says that for us to approve any facility for like a loan, majority of all members of Parliament may, through a vote of majority of all members of Parliament, give approval. I'm not reading verbatim.
You're paraphrasing, yeah.
So yeah, I'm paraphrasing. But so if you can help us with the verbatim.
So let me give the verbatim, then you give the explanation on interpretation you're seeking to put on it. Parliament may, that's 181.1. Parliament may, by resolution supported by the votes of a majority of all the members of Parliament, authorize the government to enter into an agreement for the granting of a loan out of any public fund or account. 2. An agreement entered into under clause 1 of this article shall be laid before Parliament and shall not come into operation unless it is approved by a resolution of Parliament. 3.
Thank you. So
no loan shall be raised by the government on behalf of itself or any other public institution or authority otherwise done by or under the authority of an act of Parliament.
Thank you. So the clause 1 is my interest. By majority of all members of Parliament authorized. Currently, we have a 275 member Parliament. So majority is what? 138. So what it means is that you need a vote of a minimum of 138 because that will be the majority of all members of Parliament. The underlining word there is all members of Parliament. So you need at least 138 to approve any agreement for the granting of. Yesterday, the majority side had 137. 137. When we were considering the report of the committee, and our side had 132. 132. Okay. So clearly, we did not have a majority of all members of Parliament.
So you do a vote, a head count?
We did a head count for the first issue, which was on the report.
So the majority from the head count had 137.
So majority had 137, and we had 132. So our leader got on his feet to raise this fundamental provision in the Constitution. The majority side argued, led by the majority leader, that, well, we haven't reached a stage of considering the loan and that it was just a committee report. So he had admitted this provision of Article 181, that you needed majority of all, and not just a majority of of a number of persons present. You needed majority of all, and they didn't meet that because one of their members is out of the country and was unavailable to participate. So yesterday they didn't participate at all. So when we got to the resolution and the speaker ruled on the voice vote, our side again, the deputy minority leader got on his feet.
Wanted a head count. To
challenge and request that a head count is granted. And Mr. Speaker refused.
Oh, Mr. Speaker refused the head count?
Refused the head count.
On what basis?
Well, so Mr. Speaker in a way aided because once we don't do the head count,
you can't tell from the voice
from the voice votes how many would have voted for and how many. It is only a head count that would have exposed that and would have saved Ghana another waste of what? $150 million. Unfortunately, we did not get that.
I'm curious to know why the speaker didn't allow that.
The speaker has a right.
Yeah, what reason did he give?
Well, he has a right to exercise that. The argument from the majority side was that we were abusing our rights in requesting to call for a head count because we had just asked for a head count. But that is what Parliament is supposed to. And especially when the majority leader himself had argued when the minority leader was on his feet, stating this position, clearly a constitutional provision, not even just standing orders. Even though standing orders is a creation of the Constitution, sometimes because we are masters of our own rules, our own standing orders could be interpreted by Mr. Speaker. Because that is what it states. The interpretation of our standing orders is vested in the hands of Mr. Speaker, but not the Constitution. So our minority leader was raising the Article 1811. But, well, Mr. Speaker didn't grant us that leave. So it was through a voice vote that approval was granted. If we had been given the opportunity of a head count, Ghana would have been saved the trouble of pushing another 150.
But how about the argument that, you've not reached a consideration state yet? And so, like the majority leader's argument.
No. We had then reached, because for a loan, the committee report, the resolution is then, motion is moved for resolution. Once you approve the resolution, you have approved the.
So as to speak, it's been passed. It's been done and dusted.
It's been done and dusted. What is left is for government to go ahead and do if they can draw down, it means they will draw down and possibly waste it just like the way they have wasted the other 200
They use it for the Garrett project.
Well, the 200 million was never used for the Garrett project, and you play the report. And when we
Kuma in that report said that some accounting was done to the committee.
And that's why I'm telling you, only 42 million out of the 135 remainder after taking the 65 million for COVID support was accounted for.
But Kofi, you are in Parliament and many options available to you. And
I'm saying that the first option was to block an addition. Do you pour water in the bucket?
That may not be the first option. If accounting hasn't been done, you can summon the minister or the sector people available.
But that is why we've been doing that, following through such processes, and that was why this facility should have been approved earlier. And we raised concerns. And it was upon those concerns that the second deputy speaker, who was presiding on that, they asked and directed that the leadership of the Works and Housing Committee should join the Finance Committee to further engage on that facility and possibly a site visitation. That site visitation never happened as a total committee. It took only the minority side to engage in the site visitation, exposing the things that we are telling you, where contractors tell you that we don't even know the site that we are supposed to be after receiving $2 million. So that's the unfortunate thing, and we must state this clearly, because sometimes I hear persons trying to accuse our leadership for not doing the best in terms of this fight. They did the best that they could under the circumstance, considering the numbers that we had. Just maybe if we had all our 137 and they had 137, the motion would have been lost. But unfortunately, we didn't have our 137. Of course, they are members of Parliament, are also human beings. and they are open to suffer all the vagaries that a human being will suffer. Some could be hospitalized, some would have maybe other engagements, some may be in motion and have not reached the point. So at least 5 of our colleagues could not make it to the chamber at the time that the counting took place.
Very well. You have been in Parliament for close to 3 terms, and you are used to these processes. First of all, talk to me about the minorities' attempt to block the approval of the ministerial nominee. Of course, they walked out. Majority alone passed it, which is fine. Talk to me about that. It's a tool available.
Sorry, adding that one also is a decision. And you are aware, again, you are a lawyer. The Supreme Court had ruled on the matter of the quorum for decision. When we rejected the budget, when the majority side walked out, the Supreme Court ruled that our rejection cannot hold because we did not form a decision quorum. The decision quorum is majority of all members of what? Parliament, and that is 138. We had 137 on that day, which we used in rejecting 100% the budget. The Supreme Court ruled that we did not have the quorum to constitute a decision quorum. There's a quorum for business.
So did you raise that quorum?
Yes, we raised it.
And the speaker said
that was why. No. The minority leader said, let it be registered in the records that we know their numbers and we know our numbers, because a head count has been done and we know that they are 137. So we staging a walkout, meaning that even if all of them were present, they will only have 137. And that 137 is not
a quorum.
It doesn't form a decision quorum. They can do business. They can debate, raise issues, lay papers, do all those things. But they didn't form a decision quorum. So tomorrow, you can take the matter to court. That quorum that took a decision on the ministers did not form a decision quorum.
So that decision is null and
that decision is null and void.
Is the minority planning of doing a thing like that?
Should they only be minority?
No, but of course. Other private citizens could. But you guys are there for us.
When we rejected
you guys are there for us.
No, when we rejected the budget, it wasn't the majority side that went to court. It was one lawyer, I think, is it lawyer Abdullah or
Justice Abdullah?
Justice Abdullah. He went to court. So, in the same vein, I'm providing you the information.
I see. We'll think about it. All right, Honorable Samuel.
Well, let me first say good morning to your viewers.
Yes. So yeah, on the matter of the okay. So go right ahead.
Yesterday was my birthday.
Oh, happy birthday to you then.
Thank you. A lot of birthday messages were poured on me.
Oh, belated on to you.
I have to use this platform to thank all those. Yesterday I couldn't.
So we are neighbors.
There was no way that you can't see that.
We are neighbors. We are special.
Let me start.
Great people. Yesterday I couldn't respond to all the.
So I responded to all of them once and for all.
Everybody listening to me, those who were able to send well wishes to me and those who couldn't, I say thank you. And I also want to say thank you to Dr. Mahmoud Bawumia for the work he's doing for this country. He's still on his tour. He went to Tamalis, Northern Region, and other 5 Northern regions had been done. And all what I can say in Twi, say emuye, it means it's good.
It's good.
So far, so good. Emuye pa. Yes, it's true. I've been in Parliament for 12 years, from 2017 to 2021. Some of these things are politics. You may use technicalities to see if you can block something here. First of all, I want to touch on the recall of members of Parliament to Parliament. As a matter of fact, per the Constitution and our standing orders, the Speaker of Parliament has no powers to adjourn Parliament sunny day. He has no power. The standing order is clear what should be done before Parliament can adjourn sunny day.
What does it say?
A motion must be tabled. There must be a motion. For instance, either a minority leader or majority leader or any member of Parliament can put a motion. Then there will be a secondment of that motion. if there's any rejection of the motion, that motion, counter motion should be allowed. A debate could
before Parliament's adjourned Synod.
Yes, a debate could be made. Then a vote will be cast on the motion. That is why anytime Parliament adjourns, you see all members who are in favor of the motion say aye. Those against say no. Then when you say no, they say, oh, the ayes have it. It means members of Parliament vote to adjourn Parliament, whether being Sunday or the everyday adjournment that we do in Parliament. It is Speaker, no member of Parliament, and I'm yet to see any lawyer, any member of Parliament to show me any acts, whether be in the Constitution or in the standing orders,
no,
that gives the member of Parliament, the Speaker of Parliament, yes, yeah,
except that in the daily adjournment, we have time when it is after 2. We call it, we are in the hands of Mr. Speaker. That one, you don't need a motion for adjournment.
Yes.
Okay.
But when it is before 2, which is the stated time Parliament must sit, from 10 to within 10 to 2 o'clock, you need a motion for adjournment. But after 2, we are in the hands of Mr. Speaker.
But what happened before Parliament was adjourned was after 2. Was it not after 2 p.m.?
No. When we are going home when we are adjourning Sunday night, that one, the Speaker of the Majority Leader, Minority will give his statement, Majority Leader will give a statement, and then a motion will be made, and then a vote will be cast on the motion for adjournment. So no Speaker of Parliament can just come to Parliament and say, I have closed, everybody go home. It doesn't work like that. 2, he made mention of Speaker calling Parliament. No Speaker of Parliament can just get up and say, I'm using the Constitution or the standing order to recall Parliament. There's always a timetable. The business committee will sit at the beginning of the year, and the timetable will be prepared that will guide the Speaker of Parliament to recall Parliament. So you can't just get up one day and say, oh, I want to call Parliament. But no, there's always a timetable. That timetable is prepared for that meeting.
You can leave it though.
And it's known from the beginning of the year.
From the beginning of the year.
On recess
so
this time. Parliament comes back this
exactly. Time. So the Speaker follows the business committee report that is given a whole year, the whole meeting, the timetable for the meeting. That timetable is brought to the Parliament as a document, and Parliament will pass a motion on it. It becomes a law. That Speaker of Parliament will follow to recall Parliament. So it's not a situation where Speaker can sit down and any time that he likes, he just call Parliament. No, it doesn't work like that. There's always a timetable, and that timetable has always come to Parliament. We call it the meeting, the business for the meeting. That document will be passed by motion, and Speaker of Parliament will follow to that procedure to invite Parliament. So the current Speaker of Parliament is trying to award himself a certain powers he doesn't have. So I want to ask him to at times be guided by the rules of the House. Like you can sit down and decide not to call Parliament. 2, yes, it is true, 1/3 of members of Parliament can petition the Speaker to recall Parliament, irrespective of the timetable that has been passed by Parliament. So that one is right. Number that, when we're talking about passages of loans by Parliament, Honorable Kofi Adams made mention of numbers, but there are some technicalities that we have to be very careful of. If you walk out, for instance, if you come to Parliament and you write your name on the attendance register, you know, they went to Supreme Court some time ago, and the only document that they could use to determine attendance in Parliament is the attendance register. So if you write your name that you are in Parliament, and an issue happened in the chamber, and you walk out from the chamber, and later on somebody want to go to Parliament, Supreme Court to quash the approval that is given in Parliament, Supreme Court will ask of
The attendance.
No, a document.
Document, which is the attendance.
Which is the attendance.
Document.
And you go and
but Supreme Court will also take notice of the fact that there was a walkout.
You see, one time the former majority leader, who is Honorable Citi Mensah, said, when we passed the motion, we saw 2-3 minority members still there,
not out yet.
So that one is very
fine.
difficult.
But in instances where they are out, it is clear they are out, then that raises an issue.
It is clear they are out. Who decided that there was no NDC member in the chamber?
No, but it's clear. I mean, if they are not there,
if
they are not there,
yes,
and the number in there doesn't meet the threshold for quorum.
I was expecting the NDC members, the minority, to stay, and if they know yes, the majority is not having numbers 138 to vote, to stay and vote clearly to say that yes, though we have lost the vote, those who won the vote also did not have 50% plus one or majority of all members of parliament, because if it is 132, 137, then of course the majority did not get 138. But
that's not how it is done.
No, but
we are talking about quorum here. When you want to
that should be majority.
Stays,
so that should be majority.
If 132 stays and then they have 137, then you don't have any case to raise.
Exactly.
You would have had more than one.
So once you walk out, what evidence do you have to prove that there was attendance? You go and pick attendance and the registered attendance, and you have all of them.
But the records also show that they walked out.
The record shows the record from the minority.
The record will show 137 plus 132.
Yes,
for attendance.
Yeah, for attendance.
But the records also show that they walked out. The entire minority.
That's what I'm saying. Technically, proving the walkout. That indeed all the 132 also walked out is an issue here.
How is that an issue?
So if you go to court, the Supreme Court, somebody say yes, I saw A, B, C, D, and how are you going to?
So who is going to prove that?
So how will you also prove that indeed everybody left the house? So what?
The point you're making is that there could be technicalities.
Exactly.
I don't understand the technicalities.
Yes.
They walked out. We saw they walked out, and there was nobody there. Before the vote was taken.
That is where you have a challenge. How do you know that
somebody could be hiding somewhere?
Yeah, so somebody can use that as defense. At the end of the day, don't also forget that anytime when there's a motion that Speaker wants us to pass, he mentions something procedural motion. So when you stay in the House, 132, 137, and then you vote to approve of the reports, and then in the mid of the procedure, you decide to walk out. Some of the motions that the Speaker will ask the House to vote on become procedural. So if you walk out, you are just tightening the hands of Mr. Speaker not to perform his duty. That is why when you work out, you have worked out. By this, you have approved the most important aspect of it. That's the adoption of the report. And then the rest is, it's just a matter of procedural. So we go on. Then we have a procedural motion. The motion is passed. The motion is then won. Let us also look at the appointment committee report. You see, the reports are, normally you will see the report as in one document, but when members of the committee or members of parliament are debating the report, they pick one nominee after the other. So if it's nominee A that you think we can't approve him, you go and say nominee A and B, because Kofi can't tell me that we shouldn't have Minister of Health.
What they are saying is that you could rationalize. So, for example, you could have merged, presented an opportunity for you to merge some ministries.
What I'm trying to say is that if you know there are some ministries that you think they shouldn't be there, why don't you look at those that you think should be there and approve those ministers? Because Minister for Health, we should have Minister of Health. Minister for Women.
Okay, so your point is that if there were 9 people, and they think four were important, they should approve the 4 and have issues with the 5.
But when you put all of them together and you say we are throwing everything away, then at least you don't want government to perform. So in this case, no speaker will side with you and say that, let's take the whole report and throw it out. You must be able to convince the speaker that this ministry we think should be merged. So that we think should be merged, the president should go back and merge them. Those that we need, they should stand. We pass them for them to go and do their work. But if we put all of them together and say you are not going to approve it, then of course you are trying to sabotage the government. So any speaker will give way for those things to be done, so that at least we can have ministers to do their work. You see, on this approval of the loan, my brother, if you are a member of parliament and you approve $200 million for the Ministry of Western Housing for work to be done, don't forget that we have Committee on Western Housing in Parliament. It is your responsibility as a committee to look into the documents or the approval, that the money that you have approved, and go and find out whether indeed the work is being done. Because when they bring these loans to Parliament, specifically they indicate works that need to be done by the money. So you should be able to go and find out. I've been a committee chairman before, and at times we visit sites as a committee.
So the point is that Parliament has failed in its oversight role in respect of the $200 million.
Then when you do this, then you come back to the chamber where the minister is telling you that, we have done A, B, C, D, and this is the list of projects that we've used the money for. You haven't gone there to see. You haven't submitted any report, because the speaker says that anytime committee visits any site, get a report, come and lay the report in Parliament for us to debate. If you fail to do so, and there's another part of the money that is being disbursed, then you don't have any evidence to prove that, yes, the first one has been misapplied. You see, they kept mentioning misapplication, but as a matter of fact, nobody was able to say that, the project supposed to go and build this culvert here. But at the end of the day, we have gone there and there's no culvert. He made mention that we went to the site and the contractor said he has no site. So which site did you go? He said some of the minority.
He didn't say they went to the site. He didn't say they went to the site. Yes, some of the contractors were called and they said there was no site.
So what is the name?
They are taking the money.
You see, when you say a contractor has taken 2 million without even knowing that, it's a criminal offense. So one, you should be able to mention the name of the contractor. And who gave that contractor the money to the contractor. And Parliament had the capacity to refer that contractor to whether there's OSP or the Attorney General for that contractor to be prosecuted, and also pay the money to the contractor. You can't just say that you called a contractor on phone and the contractor says he's been given 2 million cedis. He doesn't even know where he should go and do the work. And as a member of Parliament, you sat down until the second part of the money is being disbursed before you raise this issue. Then you are not helping this country. Then you are not helping Parliament. Then you are not helping Ghana. You see, if you have seen this serious criminal offense, but and you say you did not do anything about it until the next disbursement before you go and sit in Parliament, and in your debate you raise these issues, where a money $2 million has been given to contractor.
Who doesn't know the site?
Who doesn't know the site?
Or who has no site?
Who has no site? And Parliament, minority in Parliament, did not do anything about it. They didn't write to Speaker of Parliament and say, this is what we have seen. They did not invite the minister and his team because he has that capacity. You see, Parliamentary committee has the same capacity as a high court. So you have the right to invite the minister and his team to your committee to find out that we've called contractor and invite the contractor as well. The one you spoke on phone, whether he's indeed a contractor or somebody who just wanted to do something, invite that person before him. The minister, this is the contractor, this is the committee. Ask them, you see, we've called this contractor. He said you have given him 2 million Ghana cedis. You can even do that as a chairman of a committee or a minority ranking member. You can even invite president.
I see. Let Kofi answer.
So you will. Let me end this. So for you to sit and say that, we called the contractor, he said he's been given 2 million cedis. The minister is saying that I have a list of all the projects the money has been used for. We are expecting the minority to go for a copy of the list. I know at the committee level, the minister said it was given to them at the committee level. We are expecting them to show the list to the, the press and say that this is a list that has been given to us at the committee level. And indeed, this is a 2 million.
I think that point is made. I need to take a break. That point is made, and it's a very good point. So answer that. I mean, what do you mean?
We are going to take a break because there are a lot of issues that I have to.
No, just do it.
Clearly,
quickly. Yeah.
Parliament don't decide when government goes for loans.
No, but if you call the person and the person
saying
says,
Parliament don't decide.
But they are
Parliament don't decide when a government that plans to steal people's money go for more money. So it is not Parliament that decided that the Akufo-Addo government should go for another $150 million. They decided, knowing too well that you have not utilized the 200 million appropriately. They still went ahead and did their own negotiations. It was only when they brought it to Parliament and laid it that we will get to know that these same people that we have granted 200 million to do project A, B, C, D that they haven't done yet have gone asking for more. And it is the reason we have stopped that more they are asking for, because we must check the first as he's talking about. So I agree with him. I agree with him what he's saying. And that is why we said we should not approve another 150 because you haven't accounted for the 200.
Yeah, but he makes a point about the committee or Parliament itself.
And I'm saying that Parliament itself regularly have their committee work. And it is out of that committee work for which reason we say we must not approve more because we are not satisfied with the accounting that was done for the 200.
Are you saying that contractor should take 2 million?
The point is that those contractors or those people who didn't do the work or who have no sight, was there anything Parliament did to them?
That is why we raise the issues as Parliament.
You raise it at the point of another approval.
Of course. Because you have checked and realized that the first one, they haven't done the work.
No, but the point he's making is that you didn't have to wait till another approval.
No. That is not how Parliament don't force contractors.
No, but the section minister.
That is why we have what we call the Governance Assurances Committee.
Yes.
Where we summon ministers to ask them on things they've said before Parliament, before they said before Parliament, which they have not done. And these are some of the issues that are raised.
So for you, Parliament discharge is
Parliament discharge, and as far as the minority discharge is duty very. Indeed, even when Parliament referred the matter to leadership, a joint committee of leadership of Works and Housing and Finance Committee, and asked that a site visitation be conducted. You know, he has been a chairman of a committee before. And he knows that the chairman has a huge decision in what committee does or not. It is in this Parliament that we force strongly and introduce the position where even the minority can also decide to move out there, like the health committee. Sometimes the chair refuses because of plan to cover up on corrupt acts. They make sure that they don't, and the chairman can decide he will not do that. And the chairman can decide.
So this is the big issue on 97.3 Citi. We'll take a short break. When we come back, we will deal with the matters of the special prosecutor and all of that. That is a big matter we are looking at this morning. This is the big issue. Don't go away. You're welcome back to This is the Big Issue, 97.3 Citi FM. Very big welcome to our TV viewers as well. This morning, we're looking at three main issues. First issue we've dealt with already has to do with Parliament's reconvening and the matters arising. The ministerial approval, the Garrett loan approved, and the fact that the minority staged a walkout. Minority is not happy with the loan approval, and the fact that they say that the initial loan of $200 million contracted has not been properly accounted for. The majority obviously disagrees. Now we move to the next matter, which is the issue of the special prosecutor. The issue of the special prosecutor is that former special prosecutor Martin Amidu has petitioned the president in accordance with law to oust or remove current prosecutor Kisi Ejabin. Why is he doing that? Martin Amidu thinks that the man in question is not fit for the office because he has infringed on a number of things. So this is Kissie Jabin, who is a special prosecutor, took office not too long ago, but he's tried to get the office running. Mind you, Martin Amidu, this is Kissie Jabin on your screen, who took over from Martin Amidu after Martin Amidu left the office. Many think that he's been trying to get the office active after Martin Amidu started, set up the office, etc. But he really tried to take the fight to the people. Now, the petition by Martin Amidu is anchored on Section 15(1) of the OSP Act. Of course, Section 15(1) of the OSP Act, Act 959, is extracted from Article 146 of the 1992 Constitution, which deals with the removal of justices of the Superior Courts. And indeed, some offices, such as the Office of the Special Prosecutor, are pegged, their conditions of service are pegged to the conditions of service of Superior Court judges. So Section 15(1) of the OSP Act says that the Special Prosecutor shall not be removed from office except for A, stated misbehavior and incompetence, B, incapacity to perform the functions of the office by reason of infirmity of body or mind, C, willful violation of the official oath or oath of secrecy, D, conduct which I brings or is likely to bring the office of the Special Prosecutor into disrepute, ridicule or contempt, or 2, is prejudicial or inimical to the economy or security of the state. So we will have to locate within this criteria where Martin Amidu's petition falls, but we'll deal with that. Section 15 goes ahead to say that a person who seeks to remove the Special Prosecutor from office shall submit a petition to the President. That Martin Amidu has done. When the President receives a petition for the removal of the Special Prosecutor, the President shall within 7 days refer the petition to the Chief Justice, who shall within 30 days determine whether there is a prima facie case. So Chief Justice has received the petition, now forwarded it to Kissie Jabin for his response. So the petition together with Kissie Jabin's response will determine or will help the Chief Justice determine a prima facie case. Now it goes ahead to say that when the Chief Justice determines that there is a prima facie case, the Chief Justice shall within 14 days set up a committee consisting of a chairperson who is a justice of the Supreme Court, a lawyer of at least 15 years standing at the bar, and one person with expertise in investigations. The committee shall within 90 days investigate the matter and make its recommendations to the President through the Chief Justice. The President shall act in accordance with the recommendations of the committee. Now, who was the petitioner? Like you know, the petitioner is Martin ABK Amidu, a distinguished lawyer, former Deputy AG for a very long time, former Interior Minister, he's a former Attorney General himself, and he was the first Special Prosecutor of Ghana. Now, he was the Special Prosecutor because he resigned from the office of the Special Prosecutor in November 2020. Stating political interference in his work, he describes the President as corrupt, and the last straw that broke the camel's back was the corruption risk assessment he performed on the Japa Royalties arrangement or deal, which raised some issues, and he said that the presidency was interfering in his work. He called the president the mother serpent of corruption and all of that, which is a matter of public record. Now, he petitioned the president to remove the SP on 30th April 2024. The president transmitted it to the CJ on 6 May 2024. The CJ further asked for SP's comment on a letter, or from a letter dated May 16, 2024. Now, what are the areas the Chief Martin Amidu is seeking to ground his petition on? 1, he calls it encroachment of authority. 2, inducement of staff from sister law enforcement agencies. 3, abuse of citizens' rights through arrests and detention. 4, abuse of the judiciary. 5, procurement breaches. And then 6, refusal to comply with RTI request. Of course, encroachment, the very first word there, not a very common word. It means to assume to oneself without right or authority. Also means to usurp one's power. So the point Martin Amidu is seeking to make is that Kissie Jabin has usurped the authority of the president in some of the things he has done. So these are the areas. Now, is it the first person to undergo such a process? No. We have some recent precedents. Charlotte Osei, former, at the time, chair of the EC, faced a similar thing. She was eventually ousted. Jean Mensah, current chair of the EC, has a few petitions against her as well, but not much has been seen of that. Sophia Akufu, the name is Sophia Akufu, also has had a petition or so against her at the time she was CJ. Nothing much was seen around that. So this is the context within which we have this discussion. Helping us do the discussion this morning on these matters, of course, Kofi Adams, Member of Parliament from Buemi, has been around since the beginning. Samuel Ayepa, former Member of Parliament for Ayensu, and also has been here since the beginning of the program. Justice Shremsrai, who is a private legal practitioner, and then Daniel Domelevu, former Attorney General. We'll also be joined by Joseph Penka, who is a parliamentary candidate for Tempani and a former Deputy Attorney General. Let me start off. Let me start. Former Deputy Attorney General, and then Domelevu is a former Auditor General. Let me start off with Justice Shremsrai, who's been on also for a while. Justice, good morning, welcome to the program. You know, calling you Justice makes me feel like you're a judge, but I think we've had a discussion before. Welcome to the program, and I guess you're doing well. Did it come to you as a surprise that a petition has been filed against Kissie Jabin for his removal?
Thank you very much, Salom, and good morning to your viewers. Well, it did not come to me as a surprise that someone is seeking to remove the special prosecutor from office. And that is from the background that office, or any office which is set up to fight corruption, as we have casually put it on the streets, corruption would, fight back. And so I don't think that not just the special prosecutor's office, but also any other office that is set up to fight, corruption it should be ready to face some of these instances. Now, the second thing is, so I'm not surprised that there's a petition. That is also not to say that the person who has brought this Honorable Martin Amidu, is fighting, it's a corruption which is fighting back. He has established himself as one of the persons who have stood strong in the fight against corruption, and which also formed the basis for his initial appointment to the office of a special prosecutor. So, so the point I'm trying to make is that I am not saying that because I'm not surprised that the office is being pursued. I mean, the special prosecutor is being pursued out of office. It does not also mean that the person who is pursuing him out of office is corruption, which is fighting corruption.
I see. But what do you make of the person of Martin Amidu, a former, holder of this office, now going after his immediate successor? We'll come to the issues. What do you make of that?
Yeah, so I'm aware that there's some narrative which suggests that he may have some personal, is pursuing some personal fight with his successor. But I think it's neither here nor there. What we need to focus on is the grounds on which he is petitioning and the evidence which he has made available. And if he has that, it won't matter whether he has any personal issue with him or not. So personally, I think that knowing who Mr. Martin Amidu, is, I believe he's doing this as a anti-corruption crusader that he has always been. And why not? Why not him? Why not him? Because he's someone who has dedicated a greater part of his life, pursuing, in a fight against corruption. And if so, should he stop? Should he not take steps merely because it is, in this case, he suspects his successor to be the one in the act, or to be the one who has breached some laws? I don't think we should have that. We should confuse that with his fight against corruption and make a claim that he's pursuing some personal, vendetta. Secondly, when you are in public office, I think you should be ready for some of these, for scrutiny. You cannot be in a public office and say that I cannot be scrutinized by my predecessor. So long as your predecessor is also Ghanaian and he has interests at heart, I think he's even better position to actually be the one to pursue this. And I don't see any thing wrong with that.
Great. So for you, the person filing the petition doesn't matter. It is the substance and the principle that matters. Great. Now let's get to the substance and the principle. Now, Martin Amidu grounds his petition on the following issues: accroachment of authority, inducement of staff from sister law enforcement agencies, abuse of citizens' rights through arrest and detention, abuse of the judiciary, procurement breaches, refusal to comply with the RTI requests he made to him and a few others. These are interesting issues upon which Martin Amidu is asking the president to remove the special prosecutor. Many have said that some of the grounds or issues look very flimsy. What is your own view as a legal practitioner, as somebody who has seen quite a number of things happen in our jurisdiction? What do you make of the issues?
Yes, so what we probably need to do is to match those specific grounds to the grounds stated in Section 15, or in other words, this is almost a reproduction of what is also in the Constitution, stated misbehavior, incompetence, and incapacity to perform the functions of the office by reason of infirmity. So, willful violation of office, and so on and so forth. Now, if you take a violation, I have a very personal position on these things, right? And my position is born out of the Charlotte Say situation. I believe that everybody who occupies any office would breach law, right? And if the person breaches the law, there are sanctions for those breaches. We should pursue those sanctions, right? But the fact that someone has breached a law I don't think should be a ground for removal from office when the Constitution actually states specific grounds on which a person may be removed from office. So my point is that until we are able to bring those specific grounds to the general grounds that are stated in the Act or probably in the Constitution, it shouldn't be so. So you recall the Charlotte Say issue was about violation of procurement, laws. Procurement is not a core function of the Electoral Commission. So you couldn't say that the fact that there's a breach of procurement law, then it is stated misbehavior, or that it is incompetence, or that's the infirmity of body or mind. You get the point I'm making. So, for example, let's take abuse of the judiciary. Abuse of the judiciary is simply, if anything at all, should fit into contempt of court, right? And there is a procedure for pursuing, contempt of court. When someone, is contemptuous of a court or court, there's a procedure for that. And then you take luring people from the other law enforcement agencies. I am not sure exactly how that relates to stated misbehavior or anything. So long as he's doing so and people are willing to move from other places to join him, that is really not something that you could say that the person should be removed from office for. Then abuse of human rights. It depends on the nature of the abuse. Generally, the law on human rights is clear on how to pursue human rights remedies. So unless, like I said, I don't have the evidence and the nature, the details of the allegation. So I am not in any way suggesting that I'm sitting in judgment over the merits of the thing. But if it's human rights abuse, you would expect that the persons whose rights have been abused, or anyone who thinks that the right has been abused, there are remedies. Either you go to the Human Rights Court, or you file a writ, or you go to the Supreme Court, depending on the nature of the thing, to vindicate your right. I don't see that really as such. But then there's one which is very curious: refusal to give to comply with the
RTI request.
Right?
Yes, RTI request.
That could really, from what I see, that could really be ground for stated misbehavior in a very significant way. Because you see, when individuals invest their time in seeking information, and we have a law which says you should provide information, if you do not have a strong basis and you just refuse giving the information just because you don't want to give it, that could be grounds for stated misbehavior, especially when the office we are talking about is the one which is to lead transparency and a fight against corruption. So another point is that even though these individual grounds, okay, may not necessarily amount to individually may not necessarily amount to stated misbehavior, but sometimes when you put all these together, it creates an impression that the person in question could be just misbehaving. You understand? So individually, each of these grounds may not be sufficient to constitute one of the grounds, but when you put all together, it may create a different impression and create and justify a situation where you could say that the person the OSP is misbehaving or is doing things in an incompetent manner or is deliberately frustrating the process of law.
But the matter of the one you referred to, refusal to comply with RTI request, the RTI law has a procedure. I mean, if you write to the agency and you don't get it, you take it to the next step, the commission, etc. You know, so why won't Martin Amidu use those processes, but rather citing the refusal to comply with the RTI request, if that is the case at all, as a grounds for removing him? Wouldn't that be petty, especially as the law has provided an avenue or a route you can use to get the information you want? Of course, we've seen bodies in this country who have refused RTI requests. The matter traveled through the commission and they were fined. You know, they were fined, paid penalties, and then eventually I'm sure they released the information. Martin Amidu could have done so rather than running to go petition the president over a matter for which remedy is being provided by the law itself.
Yeah, so like I said, I personally have always held this view that when the law provides a remedy for a breach, that remedy should be pursued rather than going for other, remedies. So I side with exactly what you are saying. But there's a precedent. The precedent comes from the Charlotte Say situation where even though there is a specific remedy for procurement breach, it was accepted as ground for what? Stated misbehavior or incompetence for removal. So perhaps he is inspired by that precedent to go this way. And the second point I also made is that sometimes these breaches individually may not constitute a significant ground for removal.
But putting all of them together creates an impression.
It creates a certain impression that the person is determined to violate law. So that may also be, and that is why we probably need to wait for, see the evidence and the nature of, we need to see the whole thing to be able to know how that would be. And of course, that is why the committee and the Chief Justice would be having a say in all that to see whether there's a prima facie case, and if so, there will be a committee which will also look at it, whether it meets the relevant grounds for removal. But on the face of it, I think that the individual grounds, if taken individually, may not necessarily lead to that, but perhaps if you put everything together, you could have an impression of that nature that the person is either being just misbehaving or perhaps breaching law deliberately.
I see. So thanks for that. Let me move you a bit into the political arena, even though I'm sure you will resist. But others have said, some MPs and of course minority members have berated the president in doing this, in transferring or in transmitting or conveying the petition to the CJ. And they say that that's marks of selectivity because they claim that in the past, petitions have been filed or submitted against other equally important persons who come under the purview of this law. But we did not see the president in the speed with which he's doing this. We didn't see him do that. And so that means that the president is being selective. Do you share that view?
Yeah, I do share that view strongly. I think the president's conduct when it comes to, petitions for removal of such high officers of state has been, leaves so much to be there. It has been disappointing. Let me put it that way. It has been seriously disappointing over the years. There have been petitions which have been sent. Some of them would not even be acknowledged. In certain situations, some of the petitions will be ignored. Some of them take so long to even be sent, and so many impediments have been put in the way of these petitions right from the office of the president. So, and that is why it seems to be a legitimate concern when he speedily and efficiently transmits this one. Then everybody gets the impression that, okay, it looks like he has a personal interest in this one and wants it to be. In fact, but for the fact that the person who filed the petition is a man which personally I have a lot of respect for and I have confidence in, I would have also been swayed to believing that this whole thing is, is the work of the president. But I don't also believe that the president or Mr. Martin Amidu is someone who could be, easily, startled by the president to commence this. But like I said, the president's conduct in transmitting or dealing with these petitions leaves so much to be desired and has been disappointing over the years.
Very well. Thanks so much, Justice. Justice Shremsrai is a private legal practitioner, and he assisted us to appreciate some of the issues that have come up in the Martin Amidu petition to remove the Kissi Jabin special prosecutor from office over some stated grounds. Thanks so much, Justice. We appreciate your time this morning. This is the Big Issue, 97.3 Citi FM on Citi TV, on our socials, as well as a platform for incisive analysis and riveting conversation. My name is Salom Adun. Let me get back to the studio. Let me also acknowledge the fact that Franklin Kujo is on, and we'll be speaking to him quite very soon on his views on the matter. But Kofi, we've seen this before. We see this happening with Charlotte Osei, and the process started, and eventually she was removed from office. Martin Amidu, like Justice said, it's not somebody you can just throw around. So he should be doing this based on conviction. What do you make of the fact that he has petitioned to remove his successor from office over the grounds stated?
Well, thank you for the opportunity. But even before I do so, please let me just take the time giving me a minute to correct some two things. The Parliament of Ghana now has a new standing order, which was adopted, I think, January 2024. And that's what we have been using. So I made a mistake of still referring to 10 to 2 o'clock timing. We no longer work with 10 to 2 o'clock. Okay. What we do is that Parliament is supposed to sit continuously for at least 5 hours. It's no more 10 to 2 o'clock. So if you start your sitting at, say, 12 o'clock, it should be 5 hours. It means you have to sit for 5 hours continuously. Anything less than that is as if you were within 10 to 2 o'clock time, where the speaker could not on his own just adjourn to another day. Then again, the standing orders like 59, suspension of meeting. The speaker, considering where there is May, so he can also suspend, adjourn Senate without recourse to what? Leadership.
So what the speaker did was right.
What the speaker did was right from the standing.
What does it say?
It says 59.1. The speaker may, in consultation with leadership, suspend a meeting of the House indefinitely or for a period determined by the speaker, having regard to public interest and the exigencies of the state of affairs in the country.
But how about in consultation with the...
That's what I'm saying, is the may. There's a word
there's may. Okay, great.
But so he can also choose...
No, but the may there...
I perfectly agree.
But let's not go back to
You know there's a head of government business in Parliament. That's why I say in the public interest. So when there's some government business on the table for us to discuss, that's why the law says consult the leadership. There may be government business. In the case that we are referring to, there was government business.
But there will always be government business.
Yes.
All right. So that's fine. So I think that has been clear.
Yeah, that has been clear. So what the speaker did was not unlawful.
Very well.
Our standing orders.
Very well. Let's move to Martin Amidu.
Within the right. Well, for Martin Amidu, it's within his right as a citizen of this country to state his position on any matter. But I would have wished that it should not be him pursuing his successor. It should have been truly somebody else.
But if somebody did not have if somebody doesn't have the conviction,
sometimes you leave it.
So that a person
sometimes you
who has set fidelity to the law will leave things like this.
He's used some other means to communicate some of his thinking about the workings of the current special prosecutor. Even me sitting here thought that in some instances he went too far, even on those ones. I would have wished he used other means to engage, because the current special prosecutor had no hand in your leaving that office. You resign on your own because you thought you couldn't work with criminals. That's what he stated himself, that the government was engulfed with all kinds of criminal acts. That's what you stated. Kissi Ajabin was not part of government. Kissi Ajabin didn't propose the Ejapa royalty arrangement, whose opinion you wrote on, upon which all kinds of attacks came onto you, including, as he put it, the night visit by the finance minister to his home and so on and so forth. Kissi Ajabin played no role in this. So if you had any issues, you should be working to assist Kissi Ajabin to do more than what you sought to do that you could not do or couldn't stay in there to continue. But not to engage from outside frustration of the very institution that I would say you were the first person to go in there and to work around it. I strongly think that Kissi Ajabin has done something. I believe that I had some issues against some of his working, like some clearance that he did that he couldn't find. He was trying to interpret influence and so on and so forth. In the case of the gentleman who resigned, he was a former minister of state, Edubuahi, and so on and so forth. I really didn't accept the findings as he put it. But in all this, he still have done something great that deserve supporting and deserve being pushed. Then Martin Amidu just possibly gave opportunity for the executive to do what they have been looking for all this while, to try to push the man out. Don't forget his press conference that he did. He was virtually throwing his hands off that, look, I'm doing everything, but I'm not being supported. So I will just try my best, and when it is time, I'll go. It's like I'm working alone now. No cooperation from the other agencies. You try this, hey, you try that, hey, you try this, hey. And so all these arrangements, maybe lawyer Martin Amidu should have considered the larger environment and the larger interests of state.
Yeah, but I think you are creating an impression as if Martin Amidu is doing this because he feels Kissi Ajabin was part of his leaving office.
No, I'm only saying that Kissi Ajabin is not part. So if he has any issues against the system, you should be helping Kissi Ajabin to continue.
No, but he has an issue with the way Kissi Ajabin is running the office. He says he's running it contrary to law.
And I some of the things that he stated, like if you look at the Right to Information Act, if you request for information and you are denied, there are other steps to take, including going to the commissioner. And the commissioner can invoke certain rights. If it feels they can even go to court. So I don't think that the processes have been concluded on that. The other ones that he raised also, I believe that there are other ways of dealing with it. We are in this country when the GRA boss, who had reached retirement age long after, continued to stay in office. Few days to his going home again, they issued him appointment letters, backdating them. So assuming without admitting that even the special prosecutor made some appointments to the office, there are other ways that such things could be ratified and corrected, because he needed to function. And if the presidency was overly delaying and you need to function and you can't be there alone. I remember one of the things the former special prosecutor Martin Amidu was complaining about was staffing. And even at a point also, he complained about accommodation until one space was found there. I'm told he didn't even move into that space before resigning. He complained about staffing. So meaning that he himself knew that staffing was an issue and it impacted on his performance. Accommodation space was an issue and it impacted on his performance until something was found for him, though the furnishing was not done. So accommodation was solved during the Kesia Jabin tenure. Were you also expecting him to also sit and hold his hands and say, okay, I've been appointed special prosecutor. They are not giving me the other supporting staff that will make our work goes on well. So I should sit there, fold my hands and be watching. And Ghanaians will be lambasting him that he is sleeping and snoring. No, I think he took a good initiative by getting the people that he needed to make sure that he functioned.
But Martin Amidu's point is that that should be done in accordance with law.
Well,
Your board must
I'm
assist
saying,
you.
that's why I'm saying that the law, and I gave you an example of the Commissioner General of GRA, whose extension of tenure had expired, and he stayed on for a very long time, even signed some contracts including SML and what have you, and it was only recently that his renewal was backdated to cover all the years that he has been in office without any appointment or from the presidency giving him that extension of tenure. So many things could be done to correct the process. But again, you mentioned some petitions that have gone to the president. And petitions the president, we didn't hear he forward to the Chief Justice for consideration as he did in this case. What is the interest in this case just being a conveyor belt? In some instances, the president tried to block some petitions. He tried to stop, he tries to do the analysis himself to see whether to push it further or not. But in this case, boom, he's just sent it. And that is for me my worry, where I think that Martin may be aiding some persons to execute an agenda they have been looking for but have not succeeded. But generally, my position is that Kesia Jabin hasn't done badly, but there's still room for improvement. But clearly, one thing has become so clear about this whole Office of Special Prosecutor and its place in terms of fight against corruption. It may just be yet another creation that had not helped us in any way. And the proposal by many persons, including even the NDC position of a decoupling
of the
AG from the Minister of Justice, is a way to possibly go to help. Because the only reason had been that because the person is also a minister, the AG is also a minister, and possibly sometimes sits with other colleague ministers and what have you.
It will be difficult to go after them. It's
difficult for him to function effectively. So it will not be about, and if you look at the constitutional provision, almost all the prosecutorial powers are vested in the AG, except that sometimes the police could do some on his behalf, and then part of it has been taken to the Office of Special Prosecutor to perform. So I'm not too happy about this petition, truly so. I know it's within the right of Martin Amidu to do what it is that he has done. He could have avoided it. If I were in his shoes, I would have avoided it. But, well, we all know Martin Amidu, that he's not one-side person to avoid doing things that he's convinced about. But on this occasion, I think that he has aided those who rather want to stop the office from functioning, from having some opportunity to possibly put more brakes on the special prosecutor. That is what his petition for me has done in this case.
Very well. I'll come to you. But let me bring in Martin. Let me bring in Franklin Kujo. Franklin, yes, Martin has done it again. Martin is a guy known to be doing very hard things. Martin Amidu, I mean. He's now petitioned. I don't know what you think of the grounds, upon which he's seeking the president or seeking for the removal of the special prosecutor. But tell me, are you yourself, do you share in any of these grounds anyway, since you became aware of them, in terms of the work of the special prosecutor?
Well, good morning, and thank you so much for having me. Good morning to our friends in the studio. I'm a bit ambivalent in this matter, sadly. A part of me feels that the former special prosecutor should probably be interested in why Kisha Jaben is having trouble trying to scale the various roadblocks, the barriers that are being erected before him while he pursues his work. So it's a bit confounding, really, that the former special prosecutor thinks that taking on the Jaben in this manner would yield results. The other point also really for me is, Kisha Jaben's position as an OSP is also supposed to be interfacing with the public. And to that extent, if he needs to come to the public to come and basically update us as to what he's doing, that is part of his work. He's supposed to be seen to be doing his work. Whether he's achieving results or not immediately may not necessarily be the outlook here. It is the constant updates. And I think he's supposed to be updating the public, I think, twice a year or something like that.
Yes.
I don't know whether it's quarterly. I need to check. So for me, in the course of doing that, yes, he has to vent that, look, I'm doing all that I can, but there are persons I know, and I think it's also born out of his experiences that he's had in court. Don't forget, the guy he's been a criminal, lawyer for close to 20 years. So he's interacted with these judges. He knows how they think. He knows the way they behave. And you can't take that away from Kisha Jaben because he knows them pretty well. So when he's now he's not a special prosecutor, and he's seeing that if I had not special prosecutor, this judge will not behave the way he behaved. I think it is well within his right to actually tell the public that, look, I'm having challenges and I'm struggling. Basically asking for help, because well, he's probably talked to people high and mighty, and he's probably not getting through. He's probably complained to the Chief Justice. And we don't know whether any serious remedy was granted. So for me, yes, he has to say what he feels and the problems he's going through. If in the course of doing that, he probably made comments that you thought were prejudicial, well, so be it. We could take him on, but I'm not too sure what I heard Kisha Jaben talk about, complain. He actually went ahead mentioning names of judges. I don't think he even mentioned names of judges. He just said things happen. Why don't we all talk about judges' conduct? Haven't I told you that because a judge spoke about Kelly, the way we went to Kelly, and the judge said, if you guys don't know and you lose, you surcharge you. And I felt that was not quite a sensible thing to say to a party in a dispute when the issues have not even been trashed out. So I told my team, look, forget about this case. Withdraw it and maybe go and settle if you want. Yeah, I did that because I felt there was no way we were going to get justice from that guy. People say all sorts of things about judges anyway, and I'm surprised that they're even worried. Look, in America, I'm sure you know the likes of Catherine. Even in Ghana here, there are people who write critically about judicial pronouncements or rulings. People have cause to complain about what they think maybe must have motivated the judge. Some people think that our judges are too conservative. I'm part of those people who think our judges are too conservative, and they are not modern. Seriously, they are not dynamic. It's a fact. And I think judges should even be able to study economics and study other subjects so that when certain cases come before them, they will not just be looking strictly at what the law says, hey, go like a robot. Go. No. You have to be dynamic. And I think in most jurisdictions, that's why lawyers I know now, Kenyan lawyers, many of them, now go to, for instance, go for some sort of top-up courses, not just locally but abroad, just to learn some other trades, maybe economics or something like that. And I think our judges ought to rise up to the occasion. And to that extent, if somebody now criticizes you and says, the way you are behaving, knowing you, you didn't behave this way. There's nothing wrong with that, especially when the person has not even mentioned your name. It's like Kasanchi, like guilty co, like we say. So what's the problem here, really? That is complaining that he's doing his work and people are stumbling block. Is that not what is really happening? You and I, we've been asking questions about procurement issues from many institutions. Look at the procurement infractions that we see, right? Look at COVID funds. Only 25% of the funds were spent for COVID-related matters. When a special audit was done, when you start asking questions, they will throw you here, pass here, pass here, pass here. What is that? Anyway, and on that, I suspect that when he now, the former special prosecutor now says that, he even asked the Executive to give him information on the pen drive, and he didn't give him. And he told him that I don't know whether he printed the information for him, because I remember Scholarship Secretariat did that to the Forfeit States. They printed rows and rows of evidence for them. Well, maybe, yes, then you could say that, okay, look, I asked, these are administrative issues. You asked and they said they probably were not ready to give you, or they were probably thinking of how to give it to you. Yeah, maybe you can say that you don't like that what that happened, but to constitute that, for that to rise to the level of stated misbehavior, as if it was precocious, it was premeditated, I frankly, I'm not too sure. I don't think so. And so I'm more interested in the challenges the gentleman has been having with this whole issue. But let's not kid ourselves. Corruption, as what's his name, Bawumia said, will fight you back. And we said it at Imani. Look for that comment, that statement, article we published. Fighting corruption should start, charity begins at home. Fighting corruption should start at the presidency. You see, because that's where all the crooked things are cooked. That's no joke. All these big, look at the Scholarship Secretariat scandal. Is it not from there? This Ministry of Special Development Initiative, was it not harbored at the presidency, which led to all these dams that were constructed like dugouts and wasted money all over the place? Just take a casual look at that office. Everything that, so even creating the Special Prosecutor office was weak. For us, it was like after the fact. You are not coming to battle, and people with deep pockets will fight you through, but they made enough money to fight you through the courts. At the end of the day, there'll be despondency, which is why we say at the money that fighting corruption and waste begins at the presidency. If the presidency can cut off Special Scholarship Secretary, yank it off there, put an independent person there, those guys will not have the temerity to tell us that, well, this is the way we think scholarship should be done. In fact, ministers will not even qualify for those kinds of sums. So we are fighting corruption as if we are in the. You remember this book? I've forgotten. We read a book where blind people were touching an elephant, and then some people touched the tusk and said, "Oh, they think this is the mouth. This is the blind." We are in a blind alley, and unfortunately, I worry for the lives of Exeter, because we knew that this is exactly what's going to happen anyway. So for me, look, those grounds are not too solid for me. I think, as I say, my own uncle, first prosecutor, I think should rather be interested in some of the things that were not resolved, which he started. All this corruption risk analysis he beautifully worked on, and all the things he kept complaining about, and the challenge he himself mentioned it, right? He had all kinds of challenges assessing the presidency. So what does he do to them?
But there are things like abusing citizens' rights through arrest and detention, and he listed a tall list of people whose rights he thinks were abused in terms of how he arrested them and detained them. Persons like Colonel Damois, persons like even Madam Cecilia Dapa, Professor Frimpong Boateng, Joseph Eduche, and a whole lot of people, Miss Eunice Jacqueline Boa Asomahine, all those people. So the way he handled them in terms of arresting and detaining them was, an abuse of their rights, and the special prosecutor should not be seen doing so.
You see, even those matters, they are matters of course, you could take him to court. And if there's a punishment, it will be meted. Maybe some penalty units or something like that. I don't think, yeah, the manner of arrest may be problematic. I mean, I also did not like the way, what's it called, the woman whose millions have been found under her bed, for which we now I don't know what they're even saying. It's the reason why those monies were there anyway. I don't like the way that particular whole thing was done. It was too showy. It was too Rambo style. I didn't like it. And if there are issues, they should take it up against him and the human rights courts or something like that. They should do that. But to constitute that and raise it to the level of, it's as if Jabe is always involved in maltreating people, arresting people, going around. How many, really? And I'm not saying that if it happens to one, it shouldn't be complained. But there are processes through which you can complain about that, right? To raise it to the level of stated misbehavior, it's a bit far-fetched for me. It's a bit far. I'm not a lawyer, but I feel that these matters are not necessarily. I'm not too sure about that.
Really. Are you concerned, or do you fear that? I mean, given how things work, sometimes he could be asked to step aside.
Say that again.
Are you concerned that he could be asked to step aside whilst investigations, go into the matter or are conducted into the matter, and that could be the beginning of the end for him?
To be frank with you, I had wished he had resigned long ago, very, very long ago. In fact, the day he had that public interaction with everybody, that's the day he should have just resigned. That's exactly the day he should have just issued his letter, resign anyway. God, for crying out loud, I'm sorry, but this administration, Nanado himself has done very little to change the narrative that his administration has been more corrupt than anyone that we've had in the past. This act, especially this selective act, for me, I even worry about the selectivity in being a conveyor belt to taking these issues to the what's it called, to the CJ. It's another reason why I worry about the pretense of fighting corruption. Like you said not long ago, there have been many petitions, but they've never seen the light of day. So I would have thought that Jabe should actually have resigned long ago. I don't know if it is possible. Maybe he should still do it. He should actually resign. People may say, oh, he's running away from. Because look, if somebody is out to get you, they'll definitely get you. You recall that movie I told you when they wanted a stain on the judge and the Nixon trial. So what can we find on the judge? He said, oh, the other guy said nothing. He said, no, man is born in sin and in corruption. There's likely something different. And they'll do anything to procurement issues. They can obviously, he's raised the procurement issue. I think Jabe should answer that as well. But which again, obviously they'll definitely find something.
I see. They'll definitely find something. That's what you think. All right. Honorable Samaipe, frankly, he's saying that they will definitely find something to hang around his neck and all of that, and everything's work.
Well, what about if the president also wants him to go through the mail so that at the end of the day
he'll be cleared properly
to strengthen him? So it is too early for us to see whether indeed the president sent the petition to the.
But there were other petitions the president didn't bother to send.
That is where the problem is. The president, we have laws, though the law is a bit silent on whether the president had the right to send or not to send. But we apply law with common sense. So if the law says that when somebody forward the petition to the CJ, that does not mean that any petition that you receive, you don't even read through or look into the petition and you forward it to CJ because the law says so. No. That's why the president also has a team of lawyers at the presidency. Apart from that, the Attorney General is the legal counsel for the president. So the president, upon receiving such petitions, may also give it to his team or the Attorney Generals to have a look at it and advise the president. So that advice may say that, looking at this petition, even if you send it to the CJ, I don't think there's anything concrete coming out of it. Also not to create an impression that will bombard the office of the president with a lot of petitions. Some may not even hold any substance. So we know that if you see, previous presidents have received a number of petitions, not all petitions that are being forwarded to the CJ. You have to look at it, which one is there any merit.
But the law doesn't say so. The law says once you receive
that is why I begin by saying that you apply laws with you are a lawyer, you know judges do that. You don't just say the law say ABC, so
the
Supreme Court judge. I think he's a lawyer. That is why he refers.
Once he receives it,
the law did not say any time you receive.
Once he receives it. Once he receives it.
No, once you receive it, that is even.
So listen, where the president receives a petition. Listen, where the president receives a petition.
Yes.
For the removal of the special prosecutor, the president shall, within 7 days, refer the petition to the Chief Justice.
Yes. So if you are receiving and you see there's no merit, see the law says
shall. The law doesn't say that.
I've gotten the point, shall, but not all petitions that you receive that will forward.
No, who makes that determination?
It's the president and his legal team.
No, the president is a conveyor belt. Indeed.
You see, the law says so.
Our other problem is that the president has refused to be a conveyor belt in some instances.
So
you can just say that because the law says
in other instances, it's a conveyor belt.
You don't even read through and see the merit of it, then you push it to CJ.
No, but he doesn't determine the merit. You see, the merit of it is to be done by the Chief Justice.
That does not mean
that's where the Chief Justice finds
a
prima facie case in there.
Look at it.
No, he can look at it, but it's inconsequential.
The president may decide that, looking at this, yes, the law says so.
He can't decide.
As human,
the president cannot decide.
Let us look at whether it's important.
It's not to forward it. You see, it's not on human basis. If it's on human basis, we'll be having the situations we are having today. The law says that upon receipt, he shall, within 7 days, refer the petition to the Chief Justice.
But the president can also say that, I've looked through it.
He cannot say that. He cannot say that.
And that is what he has been doing, which we are worried.
Can you say
that's what he has been doing, which we are worried. What you are saying is what the president has been doing, which we are worried.
Allow him to land.
So what I'm saying is that the president, when receiving such petitions, may also look at the merit of it and see whether it is important to even go and disturb the CJ with such petitions, not to send or bombard the CJ's office with a lot of petitions. So he does that. But you see, looking at what the former SP is seeking to, Martinamid is seeking to address. If I wish I were him, I would rather write an open letter to the SP and highlight these issues for him to look at it and also for the public to debate as we are doing here and see whether this can correct some of the issues that he has reached. Because as I said earlier on, apart from the abuse of the alleged abuse of Procurement Act, the other issues that you raise are more or less an opinion. Because before you can say that I have actually abuse somebody's rights, who decide what the SP has done is an abuse? Is it lies on the mouth of Martin Amidu to say that the rights have been abused? If that abuse is indeed true as he said, then there must be a court of competent jurisdiction.
Well, you petition based on that belief that something has occurred. So he has petitioned based on a belief that
that his opinion on that matter alone cannot be.
You are right. That his opinion is not fact.
Yes, it's not binding. Yeah. That the SP might be removed from office. That's what I said. If I were him, I would rather write an open letter to the CJ for the public to look at it. But you see, there's one thing about this Office of Special Prosecutor that, my personal opinion, I think I was in Parliament when this act was passed. I quite remember Honorable Inisa Fuseni and Honorable Ben Abdullah and co debated on this issue, trying to clean the bill before it passed, because there were a lot of conflicting clauses in the act. Though I'm not a lawyer, but even if you look at it, you find it that the SP is finding it difficult to find his way as which area is within my domain where I shouldn't do. So I would suggest that the law be looking at again. At a point in time, you see the OSP as an independent body. Kofi made a statement that he can't work. Martin say he cannot work with criminals. He can't work with government. He thought government is made up of criminals. Government, the current government, members of this current government are not criminals. But you see, you are, the office of the special prosecutor, it's not part of government. You get my point? It's an independent body, just like the Electoral Commission. Can we then say the Electoral Commission is part of government? No. The office of the special prosecutor is an independent body. So let us look at the law again. At a point in time, it is the the Attorney General and Minister for Justice that can decide you can do this, you cannot do this, which area can he go. Let us look at the law again. That is my opinion anyway. Two, Honorable Martin Amidu raised an issue of poking experts or experienced staff from other existing organizations like IOCO and the Ghana Police Service. What else do we want the Office of the Special Prosecutor or the SP to do? It's quite remember when I was in Metro Mass Transit as the hour shop manager, and I applied to work with DVLA. When I got an opportunity to work at DVLA, MMT wrote to DVLA that you are in one sector ministry and they are taking somebody who has been trained by them to go and work with DVLA. After when we met on the issue, DVLA asked whether they have any bonding with me. If not, I think I'm free to move. So in this case, if somebody is working with IOCO and SP thinks he can second the person or employ the person from IOCO, you don't have any bonding. Have you any train that because of ABCD you are supposed to work with them?
So your point is that that ground is baseless.
Exactly. It is because before one person can leave IOCO to Office of the Special Prosecutor, you must, I don't know why he used the word inducement. You poke the person, you must give the person better condition of service to convince him. Other than that, he will see no need to move from where he has worked for years to come into your office. Look at somebody working at the Ghana Police Service, and you want him to leave or resign from Ghana Police Service, or based on secondment, move from Ghana Police Service to your Office of the Special Prosecutor. You must give him better condition of service. If he happens to be in the shoes of SP, of which he has been there, what strategy will he use to poke people that he has cited with a lot of experience in prosecution to come and work at his office? Will he go and say that, oh, because I am a special prosecutor, come and work under me? You must give the person better conditions of service that are better than where he is, because you can convince him to join you at your office. So for that one, I don't think.
But are you not concerned that he cites issues of procurement breaches, you know?
That one we've all agreed that is an allegation. Let us go into it and see. I think the Honorable Martin was also accused of same offense some time back.
But he wasn't, there was no petition to...
Exactly. So let us look into the petition. That is why the law says that when President receives it, send it to the CJ. And the CJ will also set a 3-member committee to look into the matter and see whether the issue that he has raised, it has some merit, and therefore, based on that, the special prosecutor...
Let's refresh our minds on the issues again. The issues Martin Amidu is basing his petition on. It says accroachment of authority, which in essence means that he is usurping the president's authority in respect of engaging the services of 3 directors when he did not have a board. All right, inducement of staff from sister law enforcement agencies, and he cites the fact that, you know, persons had been moved.
As the president complained about somebody
the president need not complain. Yeah. He doesn't have to complain. Once he feels the law is in breach.
When you don't have the board, you can act we can get acting directors.
Yeah, so
that would be acting in that capacity.
Yeah, so it's for him to show that even though he didn't have the board.
So that, those that have engaged are
yeah, so it's for that is why the SP is being asked by the CJ to give a response to the petition.
But even for the board, the president will have to give his authorization and relinquish that power of appointment to the board to be able to do so for some other staff. When you look at the act, let me just
can't we also have directors in an acting capacity?
Sure, we can have. We can always do things.
So Kisi Jabin should now come up with these responses.
Well,
and the CJ, based on the responses of the petition,
once he has been
say
served
whether
with the
there's
petition,
a prima facie case.
Once he has been served with the petition,
yes.
let's look at how he's responsible.
So it calls this one abuse of citizens' rights through arrest and detention, and he mentions how Cecilia Dapa, Frimpong Boateng, Kenneth Damoa, Joseph Eduche, Eunice Jacqueline Boa Asoma Hine, and all those guys were arrested and detained. He says that those were abuse of their rights.
Can we look at these things one after the other? You see, in this case that he has, yes, it worried. But let's leave someone like Professor Frimpong Boateng has said John, somebody where that. Before you say I've arrested him, you are a special prosecutor. You have bodies to do investigation that are working under you.
But what's
you
an
must
arrest?
be highly convinced.
But what's an arrest?
You can't just go and arrest.
No, in your mind, arrest is handcuffing somebody.
No, not about handcuffing.
He needed to be.
When he invite you to his office,
yes,
and we've learned that when he even puts his hands on your shoulder
and tells
you that you are under arrest,
he'll be questioning you.
It can be on any form.
Yes, he'll be questioning you, and he needs to give you a caution statement.
And you know, as human as we are, at times people in higher authority, we don't just handcuff them as it's being done. They invite them to the office and tell you that you sit in his office and tell you he's under arrest. But whether formula that you use to arrest a person, the fact is that the person has been arrested.
Yes, and there's nothing wrong with that because
I'm not saying there's
when you invite the person
with that. But when you arrest people and at the end of the day you don't have any concrete case against them, releasing them, that is where my family is complaining. That is where my concern is. Before you can go and arrest somebody like Professor Frimpong Boateng, you should be able to do some underground investigation.
No, but you see, the point the special prosecutor has made is that
I'll have a case
once he invites you, he is building his case, and he needs to caution you to let you know that anything you say may be used against you.
If you are the OSP, you've gone to arrest A, you start to investigate at the point in time, oh, this case is not strong enough for me to take it to court. Then you put the person aside, you go to arrest B. The next one, as a lawyer as you are, you may take some time to investigate the person behind the scenes to make sure that when you arrest him, next time you are not just going to leave off the hook simply because the evidence you find about the person is not concrete enough to take the person to court, or you cannot defend such issues at court. You don't just
let me take a few messages, take a break, and then we'll come back.
I see you have arrested people without having many cases. I think we said we have to go through this.
Yes. So Daniel Reagan says, so Martin Amido did not cough on Cecilia Dapa's quote-unquote thievery, but fighting Kisi Jabin, who is doing his best to fight corruption. You call that double standards. This one from Chris in Ashalibuchi says, Selom, Ghana has become a corruption hub instead of an economic hub. Maybe Martin Amido doesn't want the mother serpent of corruption to lay more eggs. Anyway, Martin will soon call Dr. Baumia the stepmother of corruption. That's from Chris in Ashalibuchi. This one from Emil says, the office of the special prosecutor was unnecessary to begin with. Shraj, Iyoko, etc. have not been able to accomplish anything with corruption. The creation of the OSP was a whitewashed tomb just to look good in the eyes of the public. Martin Amido suffered similar inhibitions when he was there. He should add his voice and not turn against the current special prosecutor. This is the big issue. We'll take a short break. When we return, we'll do a quick dash to Kumasi, where the funeral of the late John Kuma is happening, just to get to a feel of what's happening there. Then we'll return to the studio and continue our discussion with Kofi Adams, Franklin Kujo, and then Samuel Ayepe. Don't go away. We'll be right back. Office of the
special prosecutor.
All right, welcome back to the big issue. We are live on 97.3 Citi FM. We are on Citi TV on our socials. And it's a platform for incisive analysis and riveting conversations. My name is Selom Adunu. My guest this morning, Kofi Adams, Member of Parliament for Buem, Samuel Ayepe, former MP for Ayen Suano in the Eastern Region. We earlier spoke to Justice Remstrai, who is a private legal practitioner, and Franklin Kujo, President of Imani, is also on the program. We're looking at the matter of the Martin Amidu petition to the president to remove special prosecutor on a number of grounds he has stated to anchor his position. Key amongst those, or the grounds, if you can have them on the screen once again so that we look at them again. One, accroachment of authority, inducement of staff from sister law enforcement agencies, abuse of citizens' rights through arrests and detention, abuse of the judiciary, procurement breaches, refusal to comply with RTI requests, and all of that. These are the issues. These are the issues that he is seeking to, or he has grounded his petition on. As we know by now, the petition has been forwarded to the Chief Justice, who also by law has transmitted same to the Special Prosecutor for his response. After the Special Prosecutor gives his response, the Chief Justice will sit on the two documents and determine whether a prima facie case is being made out against Kisi Jabin. If a prima facie case is being made out against him, then she will constitute a committee made up of a Supreme Court judge, made up of a lawyer with not less than 15 years standing at the bar, and also another person with experience in investigations to look at the matter in their specifics and determine what happens to Kisi Ejabin. After that, their recommendations will be forwarded to the Chief Justice, who will also forward it to the President, and the President will only act on the recommendations. So if the recommendations say retain him, these matters are frivolous, he'll be retained. If the recommendations say remove him from the office, these matters have been proven against him, he did not have a proper response, then Kisi Jabin will no longer be the special prosecutor. That is the process, and we saw that in the case of Charlotte Osei. Now let's dash to Kumasi quickly, where the funeral of the late John Kuma is being held. A friend to my guest, a friend to all of us, unfortunately passed on a couple of months ago, and his funeral is being held today. Very big funeral in Ejiso, and currently the Vice President of the Republic is speaking at the funeral. So, Hafid, talk to us on what's happening now.
Of all, with his exceptional intellectual capacity and drive, his initiatives focused on empowering the youth and forging a brighter future for Ghana's next generation. His commitment to the National Development Program remains indelible and has left an enduring mark on the country's trajectory. He was also a lawyer of good standing. In that area too, he was brilliant, diligent, and professional in his dealings with his clients. His sudden death in March has been a personal blow. Long before I decided to run for president, Honorable John Kuma was among a few party leaders and legislators to have publicly urged me to run and pledged his unending support for my bid. True to his public pledge, John supported me strongly, campaigning with me everywhere in the country. When I finally announced my decision to contest as flag bearer of the MPP, he desired to see me win the December presidential elections. And I pray God will grant his desires for me and the party and the country. John's character was characterized by humility and unwavering principles. He was known to be honest, truthful, and sincere, an idol for the youth of Ejisu constituency. He faced his illness with courage. He was ever hopeful in the darkest hours of the struggle, but he never ceased for a moment. This demonstrated his resilience and deep-seated commitment to democracy and public service. Today, as we honor John Kuma's memory, let us not only speak words of tribute, but also commit ourselves to deeds that reflect his dedication, service, and unwavering spirit to show that he did not live in vain. My heartfelt condolences go out to his immediate family, especially his wife and children, as well as the entire Ejisu constituency, the new Patriotic Party, Parliament, and the government of Ghana. We stand in solidarity with you during this difficult time, and we pray to God to give the family and those affected by his untimely demise the strength to cope in the best way. May the soul of our dear brother, friend, and patriot find eternal peace. Amen.
His Excellency, the Vice President of the Republic of Ghana, Alhaji Dr. Mahmoud Bawumia, the MPV's flag bearer for election 2024, aka it is possible. Dr. Digital, thank you very much. Abajo also for sorry, so for Yanko. Some of Bajo mentioned I'm here, Missing Tidame, boy, Yanko. The better Omampeni Abedi, Alhaji Dr. Mahmoud Bawumia, Dr. Digital, it is possible. The better na say. Maybe I do a Nanamani Diemwa. It is possible. Dr. Mahmoud Bawumia, Dr. Digital. Where are you there? The German Sofono. Na the Akano Atroso. Baba, Adaroma, Yantoso. Amen.
Reading of tribute. The standard fans are not working, but your technicians no. I'm sure your fans.
Baba, man, say microphone here. Anyway, some matter the way. Amen.
Technicians, yes, I'm sure not fans no. Any juma.
Yes, yes, I can hear you. Yes, I can hear you.
On the third of the
reading, so we are in the second part of the event. So the children of the late Member of Parliament for Ejisu have been called to also pay tribute to their late dad, who is expected to be buried today. And just gone by was the Vice President of the Republic of Ghana, who read his tribute, and he shared some fond memories of the late Member of Parliament for Ejisu. And he has been talking about how John Kuma supported and encouraged his intentions to become the flag bearer of the new Patriotic Party, and also the flag bearer of the new Patriotic Party, and also his presidential bid. So the children have been called now to read the tribute. We are to take some to listen to what the are reading.
Children, there is no doubt that our father, Honorable Dr. John Ampontia Kuma, was the chosen one of this generation. A beacon of hope, a revolutionary thinker, and a steadfast advocate for his beloved Ghana. Today, we are gathered here with heavy hearts to bid farewell to a remarkable man. As we stand here in solemn remembrance, we celebrate a life that touched so many, a life that will forever be cherished in our hearts. Our father, Honorable Dr. John Ampontia Kuma, was more than just a father. He was a beacon of strength, wisdom, and love. His presence filled our lives with warmth and guidance, and his absence leaves an irreplaceable void. We have not grown as children, but for the years we saw him as our father, we have witnessed hundreds of lives he has touched. As we reflect on our father's life, we are reminded of his unwavering dedication to his family. He was a loving husband, a devoted father, and a pillar of support to all who knew him. His love knew no bounds, and his kindness knew no limits. Our father was a man of unparalleled courage and conviction. He charted his own path, unyielding in his dedication to his principles and unwavering commitment to serving humanity. He was not just a leader. He was a mentor, a guide, and a source of inspiration to all who knew him. We fondly remember a conversation with our father where he spoke of his refusal to emulate others. He was a man of originality, driven by his own revolutionary ideas and fueled by a passion for change. He instilled in us the belief that greatness lies in being and that authentic leadership stems from within. Despite the challenges he faced, our father remained resolute in his pursuit of a better future for Ghana. He faced criticisms and adversity gracefully, never wavering in his belief that he was serving a greater purpose. He taught us to be resilient in the face of adversity, to rise above negativity, and to hold fast to our convictions. Just over 2 years ago, my father treated my mother and me to a birthday celebration. During that time, a prominent figure in our nation had passed away, sparking a flurry of negative commentary in the media. Amid this, my father spoke to me, assuring me that these disparaging remarks were baseless. With sincerity in his eyes, he said, "My dear daughter, do not entertain any negativity about me after I am gone. Even if my time on this earth is to end today, know that I have served my country and fulfilled my purpose. I am ready to return to God. Never believe that someone had killed me. No one can take my life." His words took me aback at the time, but now, with clarity, I understand and sincerely appreciate his unwavering conviction. In his lifetime, our father taught us the importance of compassion, integrity, and resilience. He faced challenges with unwavering determination and emerged stronger with each trial. His resilience was a testament to his steadfast spirit and unwavering faith in God. His favorite mantra was, "God is my first and last reward." Indeed, he was a man of God. Our father's love for his country was unwavering, and his dedication to his people was unparalleled. He lived with integrity, compassion, and a fierce determination to make a change. Even in the face of unwarranted criticism and negativity, he remained steadfast in his belief that he was making a meaningful impact. Our father's legacy extends far beyond the confines of his world. His passion for life was infectious, his laughter contagious, and his spirit indomitable. He approached each day with courage and grace, inspiring all who crossed his path to embrace the beauty of life. As we bid farewell to our beloved father, we take comfort in the knowledge that he has left an indelible mark on our lives and the lives of countless others. His legacy will continue to inspire us to stand up for what we believe in and always walk with courage.
That was the reading from the children. And we are welcoming the widow. Open up. Maybe some air back. Maybe also the music painting.
All right, so welcome back from that sad event. So the funeral of the late John Kuma, former deputy finance minister, member of parliament for Ejiso. Indeed, his replacement was sworn into parliament yesterday when parliament parliament reconvened. All right, so this is where we are. I mean, some more things to talk about, but let me just take your quick thoughts on John Kuma and the funeral.
Very sad situation, or sad news. A very young person, 45 years, acquired a lot in terms of education. A lawyer, a member of parliament, have a PhD, and a deputy minister. I think it's what his prime stage or age in which he's going to contribute a lot into the betterment of this country. Very sad. Looking at the children he has left here very young, that they may need his support to also grow up to be mature citizens of this country. I think it's a very sad situation. We should try as much as we can to find time of our busy schedules to take good care of our health. I'm not saying that he did not, but rather just drawing the attention of Kofi and others to take some time out of their busy schedule to know what is going on in the body, to eat well, to do a lot of exercise, so that at this prime age of 45, we will not lose such important personalities or people who are in a position to assist in the development of this country. It's not only his family that have lost, the whole country, because we cannot invest so much in such a gentleman only for us to lose him in the manner in which we've lost Honorable John Kuma. It's very sad. May God receive him in heaven.
All right, Kofi, we'll be going to the funeral grounds to fully cover that from now. So your words on John Kuma and all of that.
Well, John was one MP that was very reachable. You could reach him from even the other side, because we used to tease ourselves, especially, the last time we were looking at the e-levy and the issue of advising government to consider another engagement with IMF, and he was the point person who said, as far as the MPP government remains in power, we won't go to IMF today, we won't go to IMF tomorrow. So anytime I saw him, we stopped using our aim and shoot, the aim and shoot, and don't delay. We stopped using that one and using IMF, and then he would respect IMF for China. We made fun of it. Yeah. That was the person that he was. We were at the funeral of a colleague of his, Dr. Ophelia Brandt, who hails from my hometown, Tetema. And little did we know that, and that was his PhD mate. She also left in the same manner. Little did we know that John was also going to go so soon. It's quite unfortunate, but I agree with Honorable Aipe that, look, as servers, especially members of parliament, we need to take our health issues seriously.
Great.
Because you think so much about the people you lead that you tend to even forget about
your own health. I see. Great.
You tend to forget about yourself. And sometimes it's not even costly. We have a small clinic in parliament, yeah, but we don't even have the time to go, because that time you think that you should even go to the clinic, you think you should be chasing something for your constituency. Something has happened. You need that time rather to chase for them instead of going to see.
And you're not paying anything. Just present yourself.
No, you are not paying. Just present.
The initial test will be done on you.
Even if they check and they find something that needs further treatment,
they refer
you to a bigger facility.
They will still possibly take care of that cost. But even just the time to do it, we don't.
Wow.
You are spending all the time trying to solve many other person's problem. Then, it happens to you and you are gone.
Unfortunate. Franklin, just a quick one from you on the funeral and all of that. All right, so we don't have Franklin. So we are ending our broadcast of the big issue today and going to Ejiso to bring to you the live proceedings from the funeral grounds. Thank you so much for.
But you should have given us your 1 minute on the CD.
Yes. The CD is
that was really a major.
Yes, the CD is not going. It's not going anywhere soon.
Well, I may not be here tomorrow to come and talk about it.
You'll be here.
Clearly, government has failed in managing the economy. It's terrible. You can't take an economy where the exchange rate was less than 4 CD, and today you subject it to about 15. CD to $1. It's untenable, and government must do something about increasing production of cocoa. They must check the gold issues and then what have you. There's so much smuggling of our gold, and the gold and the galamsey activities have reduced cocoa production. But meanwhile, this gold is also being smuggled out, and
so there's no foreign exchange
benefiting from it. So you have reduced cocoa
and the gold, we are not
seeing it.
And so the foreign exchange
shortfalls, creating all kinds of challenges.
We'll table this discussion again. We'll table the discussion again next week.
The fact remains that there has been an international crisis.
So the crisis is the issue. All right. So Franklin, I was taking the views on John Kuma. Just 1 minute, then we'll go to the funeral grounds. Franklin
is going through, and we know with time, government is working
to
make sure.
Yeah, just 1 minute, then we go to the funeral grounds on John Kuma and all of that. They are laying him to rest today.
Well, all I can say is that may his soul rest in peace. John was a good guy. He was a good man, and we'll remember him forever. Thank you.
Very well. Thank you so much, guys. We had to go, so thanks so much for coming. Kofi Adams, the Honorable Samuel Ayepe, Franklin Kujo. Thanks so much for joining the discussion, and to you out there, we are moving to Ejisu to continue with the funeral of John Kuma. Very unfortunate event, but our thoughts and prayers are with the family and the children and all persons who were associated with him. Thanks so much for doing the viewing and the listening. My name is Selom Adon. We'll catch you same time next week for another exciting edition. Have a good morning.
One of the best marriages in Ghana, I can proudly say, John, our own was the best. Udi ni die ni animonyama ese fata nyina ma me. Udura sorry dem na wo se wotena se. Na me kasa kire wo a wotena se no afre me mama. Uduru baby a wo se wo frɛ me girlfriend na wotimi ka. Kwakwa na wo koi. Why na me kasa wie be preach we no betimi aka kire me sa ma wo ye ni se ya ke be yeye. De na mama ni je kra ne the thumbs up. She say na wa bomode. Na se mi dru fia na wo wa fi me mama so asa ka chem say the great apostle, the only queen. And emrani we nyina me kasa wie na me bra me nya obi anka biem. Na so me cheche me re e wo nyankopon asem mu. Osankafo wo matimi ensa cheche mu ba akon de koka na me ensa. Wo se bibiara wo ne mre e wasasi so. Odua wo ne bre na otwa wo ne bre. Owo wo ne bre na awo wo ne bre. Serie wo ne bre na nisun wo ne bre. Ebre mu odam ni ubo mu. Se ne abani seya. So anso na magina. De me na wo nyina ne se me se me kan krata we ya adebechi. He said de why doso. Na de me pesa me mouth ya sense na wo ye ni papa. Wo ye ni papa. Obi anwie peye na so John wo danso. Wa ye mu ye wo tsema adwen pa na boroso odo eli said ye tiny page minya wo subie mu da be me na ho na pa And the person may come out here as meaning so on coy. What I saw her would see me, if you say me to ne. And he say, Nima watching you not da. Dear, what do you want me munina? Ye bechina. O man, your mama done. I mean, so I come as wadi no. But baby, I also that you could do ye. So with them afraid beduru. Take it. Kweku. Ampontria. Me do mo betra. E we Yesu din. E beduru ho wate. Obrenya kwada. Why ye be? Why ye be? Me say we you okuri ni kese. You are my hero. My king. The fighter. I love you. And I will cherish your memory forever. Till we meet again. Johnny, honey boy, JK, rest and rest in peace. Amen.
That was the reading from the widow. We are continuing the reading of the tribute. At this very moment, you are picking a tribute from the Parliament House. Because he was a member of Parliament, it is due that we accept a tribute from the House. This very moment, he has 5 minutes. We know they are good in summarizing. And by that, we are asking that whoever is going to do that for us will do it in a
Deputy
for
Clerk
us.
of Parliament, Ahuma Ajiato. Mr. Jatro, Mr. Jatro, Onona Ebekai Amayan, Deputy Clerk of Parliament, Ono and Ebekai.
He is coming, and then Ministry of Finance will give us a tribute after the Parliament. So a rep from there should be ready. Thank you very much.
Tribute by the Parliament of Ghana. Then I heard a voice from heaven saying unto me, Write, blessed are the dead which die in the Lord from henceforth. Yea, saith the Spirit, that they may rest from their labors, and their works do follow them. Revelations 14:13. It is with a very heavy heart that the Parliament of Ghana pays tribute to the remarkable life and distinguished service of Honorable Dr. John Ampwetua Kuma, a true patriot, selfless and visionary young man who has undoubtedly served the nation with a sense of commitment and dedication worthy of emulation. Indeed, news of the passing of Honorable John Kuma was received with great shock and trepidation, particularly so when we became aware of the tremendous rate of recovery from his ailment. Tuesday, the 7th of March, 2024, has thus left the Parliament of Ghana with an indelible, painful memory of his passing, and we can only pray for the good Lord to help us overcome. Honorable John Kuma became associated with the Parliament of Ghana when he was sworn in as a Member of Parliament for the Ejisu constituency in January 2017. His diligence and dedication to duty as a legislator and trustee of the good people of Ejisu and Ghana became noticeable right from the beginning. He was a man of boundless ambition who always strove for excellence, both in his role as a legislator and a statesman, with a firm conviction in the maxim that the sky is the limit, often challenging conventional boundaries. He effectively combined his legislative role with his executive function as a Deputy Minister for Finance, serving Ghana. As a legislator, Honorable John Kuma distinguished himself on the floor of the House and in various committee settings. Despite being a first-time MP in the 7th Parliament, he emerged as one of the leading voices on the side of the majority, making significant contributions to major government finance and economic planning measures. His memorable intervention during the passage of the 2024 budget statement and economic policy of the government and the Ye Levy Bill underscored the depth of knowledge and insight he possessed. Admittedly, Honorable John Kuma was not just a good debater, he was a very tactful and skillful in making his submissions without necessarily provoking debate or stirring controversy, a trait which earned the admiration of colleagues. Honorable John Kuma did not just exemplify prominence in his representative, legislative, and deliberative roles. He also excelled in his oversight responsibilities, mainly carried out through parliamentary committees. Although an active member of the executive with a busy schedule, in no less a ministry than the Ministry of Finance, Honorable John Kuma devoted space and time to serve diligently on the Employment, Social Welfare and State Enterprises Committee, the Appointments Committee, and the Constitutional, Legal and Parliamentary Affairs Committees, where he contributed significantly towards committee oversight with wisdom and expertise. His uniquely calm disposition and conciliatory demeanor were virtues which drew colleague ministers and MPs as well as staff of the parliamentary service closer to him. He exuded humility and was therefore approachable to the old